Good morning.
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 Before we begin, I just want to make sure we have everyone. All right, we have our court reporter today. Good.
Is it okay if I just write down the names real fast?
You bet. Go for it. You've got, why don't the two parties introduce themselves, give the name of the case? Or the names there. Well, yeah, I'll do it. Mr. Mier, who's the plaintiff in this matter. Michael Mier, M-I-E-R, is that correct?
Mier, yes.
Mier, pardon me, I've been calling you Mier all along. And
okay.
We have Mr. Langschweiger, who continues to keep the correct pronunciation of his name a state secret. But I'm going to call him.
For some reason, we pronounce it not entirely German, but partially German. It's Langschwager. The W doesn't turn into a V for some reason.
Gotcha. Thank you. All right. And we have our court reporter, and that's Mr. Langschwager's Langschwager.
Correct.
Is there anything else you need, court reporter, before I call the case?
No, thank you very much.
You bet. All righty. All right, I'm going to call the case. This is the matter of, you just told me how to say it, and I keep saying Mier. What is it, the name again, sir?
It is Mier.
Mier. Okay, got it. All right. So we have Michael Mier versus Department of Corrections. It is case number, in the Court of Claims, case number 23116. And a couple of preliminary things. First is on February 27, I think it was, I denied several of the plaintiff's motions, but I granted a motion to stay the order that permits the destruction of the USB drive. Mr. Landschlager, do you anticipate that your client's going to be complying with this?
Yes, in fact, he's been contacted and told not to do that.
Okay, thank you. All right. I do want to address one other preliminary matter because there were several motions filed by the plaintiff, and I did do some research regarding jurisdiction, and I just want to put that on the record since this matter is likely to go up on appeal. I've reviewed court rules 2.614A, 7.209A, and 7.208A, as well as two cases in re estate of Rosenberg, unpublished docket numbers 215371 and 216741, as well as the Michigan Supreme Court order in Third Judicial Circuit 480 Mich 994, specifically footnote 3, which indicates that this court has jurisdiction to decide matters of stay and enforcement of orders. Despite the fact that the state has filed a claim of appeal, I don't see that Mr. Mier has yet filed one, but I know that he might. So according to my notes, the only issue before us is the order regarding access to the CD, DVD materials that I issued on February 27th. Mr. Mier, you indicate in your motion that the defendant has advised you that they either will not comply with the order or they may not comply with the order. So let me turn to Mr. Landschlager and ask you, what is the status of the department's compliance with that order?
From what I understand, Mr. Fager has not allowed Mr. Mier to have access to a computer with the CD, DVD capability.
Well, I'm not sure I understand, since, you know, I mean, you may disagree, but there is an order in effect, and on what basis does the DOC decide they don't need to follow it?
Well, Your Honor, we're relying on there being no immediate effect given to the order. Because it says if with an injunction it may, and so in this case, this was within the time frame for an automatic stay that's normally entered. And on top of that, Mr. Mier has also filed a motion for reconsideration or rehearing, which also acts as an automatic stay.
I believe I've denied his motions for rehearing, haven't I?
Yes, and I believe there's a 21-day aftermath after that too.
That's correct. Before an order can issue of enforcement, I agree. So, help me here. Is the intent that the department, is the department's plan, and you're advising them to refuse to comply with the order until such time as appeals has reached a decision?
Well, we would hope that the court either clarify that today. We would argue, you know, that this should be decided by the Court of Appeals. The next hearing for Mr. Mier isn't scheduled until 4/19, so by then we will have an answer.
From who?
From the Court of Appeals. We have filed, yes, we have filed a motion for emergency stay in this case.
I see. Okay, I haven't seen that one yet. That must have happened late last week or something, because I somehow missed it. Very good. And Mr. Mier, have you received a copy of the motion for emergency stay?
I was not served directly by Mr. Langschwager, the department. I received something from the Court of Appeals because they sent it back because they were waiting on transcripts under the court rule.
They did say that they're waiting on transcripts, and we will have a transcript filed tomorrow.
Okay, so you have an emergency motion for stay pending in the Court of Appeals. That is
correct.
All right. And I presume, Mr. Mier, that upon receipt, you're going to respond to that.
Yes, I would like to point something out under MCR 2.614.
Hold on a minute, Mr. Mier. Mr. Mier, before you get going, let me handle this. I'm going to let you say whatever you want to say. All right, then I have to make a determination. Mr. Mier, it's correct that your hearing for a new trial is on April 19, is that right?
17, April 17.
Okay. All right, and it's now the beginning of March. I think the defense is probably right that they'll get a ruling before the end of March, maybe even sooner. All right, well, I'll have to take all that into consideration in deciding whether to issue some type of order of enforcement. Now, Mr. Mier, I haven't given you a whole lot of time to look at this material. I can't imagine it's going to make a difference if you view it now or if you view it in 2 weeks, since you have until April 19th. And then, of course, you have much longer to file your brief on appeal. So I'm inclined right now to allow the Court of Appeals to make its ruling, assuming that one happens within the next couple of weeks. But I'm going to think of that a little bit. But go ahead, Mr. Mier. You can make your argument now if you want.
Okay, first I'd like to point out to the court that under the court rule for stay under MCR 2.614,
Yep.
it specifically says nothing in this rule prohibits the court from enjoining the transfer or disposition of property during the 21-day period.
That's
so
right.
there isn't an automatic stay when it comes to property.
Well, I don't think there's an automatic stay. I mean, the defense's position is that, but you don't have to. I don't think there's an automatic stay here. But he has filed a motion for stay,
Right.
which, if granted, would negate my order, at least until such time as the court passed on it. But go ahead, you can continue.
All right, and so I have a request to adjourn this hearing today because I was not given it on the basis of the response that I did not receive from the defense until just this past Thursday. Today, this morning, I filed a motion for discovery and a subpoena. I actually,
Mr. Mier, let me cut you off. You can't file a motion for discovery now. Okay, I understand what you want to point out, that these devices exist. I'm just going to take you at your word, and I mean, surely somewhere in the prison there are computers that have CD and DVD access. I'm not too concerned about that. So, but go ahead. And the question. So you want to adjourn this until you have a decision on that motion. I'm either going to deny that motion or conclude it's not properly before me. So what else have you got?
well, I'm just concerned about preserving appellate review because if I don't have any evidence that there is actual CD readers, the Court of Appeals might take that position. So if I could just give testimony at least.
Okay, I'll let you do that in a minute. Mr. Lanfrager, is there a dispute about this? I saw Mr. Fagan's, I think it was his affidavit. Is that really your position, that there's no place in the prison where this can be viewed?
That is not what the affidavit says. It says the computer is assigned to the prisoners.
Okay.
And the other thing we have to look at is whether or not, even if there was a CD or DVD,
right,
a capable computer in there, does it have the software to run what he wants to run?
It does, though. I witnessed it. It just, the administrative settings need to be removed is all. I dealt with this in the county jail.
Hold on, Mr. Mier. Mr. Mier, hold on. Go ahead. Would the court reporter please swear in, Mr. Mier?
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
All right, Mr. Mier, tell me what you witnessed regarding use of a computer, a computer which prisoners have access to for viewing CDs or DVD materials.
Okay, there are 2 computers set aside for legal clerks, legal writers is what they call them. These are inmates who write briefs on behalf of other prisoners.
I know they are.
They actually, okay, and they have assigned USB devices that they have access to that they plug into these computers. And those computers also have CD readers. I witnessed them being opened and closed. And I also witnessed that the computers have a video viewer, they have an audio viewer, they have a photo viewer, and those applications just have administrative settings. And all that has to happen is the administrator, who would be Fager, would have to lift those administrative settings to give access to actually access the material that's on the DVD.
And where are they located, the computers with access?
They are located in the law library, and I'd like to give you, they have service tag numbers.
You've given me in your affidavit, right?
Yes.
I've got
I sent
them.
an affidavit. Okay. All right.
All right. Did you receive this affidavit, Mr. Landschrager?
No, what I got from Mr. Fager on Friday was a subpoena that Mr. Mier had issued. Apparently, he thinks he's an attorney, but
I don't think I'm an
affidavit.
Okay. All right. Well, since it's unclear, Mr. Mier, whether this has been properly served, go ahead and give me the service tag numbers of those computers if you have them.
Okay, the first one is O as an ostrich, FT3Y2. The second service tag number is 5K, O as an ostrich, Y3Y2.
Okay, very good. All right, Mr. Lanfranco, back to you. I mean, does the department deny the constitutional right to have his materials for appeal?
Well, it's not the constitutional rights for materials for appeal. You have a format problem. They wouldn't deny documents, but we do have something where it is an item that is not expressly provided for in prison. You could extend
Right.
this out to other cases. Let's say that a phone was at issue, and a prisoner can't have a phone in prison to do like some kind of a forensic test. And,
Uh-huh.
just because there could be evidence on it or it's capable of containing the document doesn't make it acceptable to bring it to a prison.
Well, what is the department's suggestion as to how Mr. Mier can view digital exhibit, which are not available on paper?
This might be something he has to set up with his trial court.
And how would he do that?
I suppose they could, just like we have a Zoom hearing, they could play it for him.
So are you saying he should be writted to the jail to view this stuff?
It should be, this is part of his underlying criminal trial. Am I correct?
That's correct. That's what I'm concerned about.
And so that's probably the more appropriate place for it with the judge in that case. Since ultimately this does impact that case.
Well, Your Honor, I have prepared a motion for bond regarding this issue, and I don't think that the trial court is going to issue me bond, but they could writ me to the county jail for a period of time to complete the task that I'm trying to complete. And I would just like to point out for the record once again that your order actually doesn't accomplish the things that I'm trying to accomplish. I'm not trying to just look at the information. I need to be able to duplicate the digital information onto a separate media device and send it out to an expert so that he can review it for due process under People versus Kennedy and Ake versus Oklahoma.
Okay, you're going to have to get that relief from the trial court. I'm not going to grant you either bond or access to an expert. At
Well,
this
I'm not.
point. Mr. Mier,
I'm
let
not
me finish.
asking you for bond.
Okay. Do you want to be writted back to the jail? I mean, I know there are consequences to losing your space in the prison. If that could resolve all this and you can view everything in the jail, I'd be delighted to get this thing resolved. But do you have any objection to that?
I mean, and you're right, there are consequences, but I'm willing to sacrifice those consequences absolutely to accomplish what I'm trying to accomplish here. But at the same time, there's a need, and I think it'll go to the Court of Appeals to figure this all out, for future, because every prisoner shouldn't have to go through all this just to represent themselves on their appeal. There needs to be some major policy change here within the MDOC. They need to figure out how to meet in the middle, because as you say, I have a constitutional right. So the agency has to accommodate in some respect. We got a prison full of people.
Mr. Mier, I understand the broader policy question. And in fact,
right.
I'm going to raise it with the Prisons and Corrections section of the State Bar to see whether or not, with the cooperation of the DOC and public defender or whoever deals with this thing, some type of policy can be addressed, because as the time goes on, we're going to see more and more digital exhibits, and obviously the jails are pretty freely giving access to this stuff. So it seems like the DOC could use some updating, but that's not what I'm here to do today. What I'm here to do today is make sure you can see what you need to see. So I can wait to see what the Court of Appeals does on this motion for stay if they deny it. I presume, Mr. Landschreiger, if the Court of Appeals denies the stay, that I won't have to order execution, that it will simply be followed. Is that right?
I'd have to talk with my supervisor, but yes, that is a possibility that your order would be immediately, somehow, I guess, giving them access or,
Okay, is that a yes or is that a maybe?
That is I guess a reserved answer that I would anticipate that it is possible that your order would be followed. It is also possible that they, might say no. But at this point, if the Court of Appeals says no to it, I really don't see the not being able to get around complying with the
Okay.
order.
All right. So then I don't think it's necessary, Mr. Mier, to put you to the trouble of being written down. I'm going to let you each speak again in response to my tentative conclusion here, which is that I'm inclined to allow some time for the Court of Appeals to issue a decision on the appeal on the motion for stay. If they deny it, I understand that the order will be complied with. If they grant the motion for stay, the matter is out of my hands or my successor's hands. My intention then would be to adjourn your motion for adjourn your motion for execution on the CD-DVD until such time as the Court of Appeals makes a decision on the motion for stay, but I'll put some deadline in there after which I will order, or my successor will order a execution if we haven't heard back from the Court of Appeals in time for you to review the materials prior to your hearing, which I think you said is on April 17. So having said that, both Mr. Mier and Mr. Landschreiber can respond, if you like.
Go ahead, Mr. Langschwager. First.
At this point, well, it's your motion, Mr. Mier.
I know.
At this point, the court has ruled, and what you've said so far, we would agree that that is probably the best course to take in this, other than to, I guess, reconsider the stay or the prior motion for staying the delivery of the CD-DVD, which isn't before this court. So I believe the court's on the right course.
Thank you, sir. Mr. Mier?
Okay, so you had suggested something about accomplishing a potential bond situation or a writ back to the county jail.
Right, I had thrown that out as a possibility. However, let me explain that if the Court of Appeals issues a stay, being written down will not be of much help to you. Although it might be, I suppose, but I question that. And if they don't, then the state is going to comply with the order to allow you access as previously ordered.
Well, if I were to convince the trial court to allow me to go back to the jail for a period of time to work on my appeal brief and the hearing, would I be able to have access to the thumb drive there?
Well, remember the order says you can direct that the thumb drive be sent to anyone who's not a prisoner. You could, Mr. Landschreiber, I presume there'd be no objection to him having it sent to either the jail or the circuit court.
The circuit court, there'd be no objection.
Okay, the jail you would object, so the circuit court would have to send it to the jail.
My problem with the jail is I don't know who would have it at the jail, and I would trust the circuit court to put a tighter constraint on it and to supervise the access to it.
Well, what if I send it to the sheriff who manages the jail? And then obviously the sheriff will do whatever their procedures are. I'm not gonna,
I believe that's a possibility too, to have the sheriff overseeing that, and with probably the stipulation that nothing else be put on it.
Right.
Because I don't know what is on there, and
right.
And there's always the possibility that a virus or malware could be put on there.
Okay. Although of course the plaintiff hasn't had access, but I realize he's not the only person who could do that.
And that it still can't come into the prison after the sheriff is done with it. If it is the sheriff or the circuit court.
All right, and you have the USB as well, right?
The USB is what we were just talking about, yes.
Well, I meant, and the CD as well.
Oh, and the CD as well, that, yes, it could, I think at this point, we didn't discuss whether or not that could be sent out. The only thing we had with the CD is you wanted to provide access, but yes, right. I suppose that those could both be sent to the jail or to the sheriff's or the circuit court back.
All right. So, Mr. Mier, what do you want to do?
Okay. Well, I just wanted to get that clarified. I am going to try, I think, and have the trial court writ me there for a period of time before the hearing and after the hearing, because I want to be able to prepare my brief and duplicate some of the digital stuff to put it in an appendix. I know that might not be necessary, but I feel it'd be helpful to the Court of Appeals. Okay, and that's essentially what I've been trying to accomplish.
All right. Go ahead.
Okay, and finally, I mean, that's it for that, but I did want to ask the court to reconsider the damages. Because I, as a prisoner, I am exempt from initial disclosure under the discovery rules for items of damages and for evidence related to damages. And that would
All right,
be.
well, I'm going to deny that motion. I understand your position. I reviewed it several times. Anything else?
Oh, yeah, one more thing. So you did issue an order on the post-judgment motions, and you do have jurisdiction for stay and bond matters, but you actually don't have jurisdiction to hear motions to reconsider or to amend your final order.
That's correct.
So
And I did issue some. Well, I denied the motion, so I don't think it's terribly significant. I mean, you can make whatever argument about it, but I don't think I granted any relief based upon motion for reconsideration, did I?
No, you didn't.
Okay.
I just wanted to put it on the record in case it becomes an issue in the Court of Appeals. And I'm worried about preservation. Actually, honestly, I think even the issues that I raised in my motion for reconsider are actually preserved. They're on the record.
Of course they're preserved.
Material.
I mean, as long as you raise them initially, they're preserved. You know,
right.
If you raise something else, then that's a decision for the Court of Appeals.
Right.
Okay.
Right.
All right. So I'm going to get an order done today, or certainly tomorrow, if not today. And just want to make sure I have everything straight here. That I'm going to order that the motion for enforcement regarding CD and DVD is stayed pending a reasonably prompt Court of Appeals decision, and I'll put some date on there after which the motion to enforce can be, an order to enforce can be entered. And that this is without prejudice to Mr. Mier filing any motions to be writted to the jail. I think that's it. Okay, anything else?
The other thing is I had said 419 as far as his next hearing, and you repeated it one time. It is 417, and I misspoke when I said that. So I just want to make sure that it's definitely 417 if that goes into any orders.
Great. Thank you. Mr. Landschwager, do you know, is there any internal process that has begun in the department to address digitally stored trial exhibits?
That is a great question for the corrections section, because you'll have somebody that's more structurally involved.
Sure.
So
okay. Well, I am going to pass
it
on to them. It'll be up to them at that point. Okay. Very good. Thank you. I think unless there's something else, the hearing is concluded, and we will issue an order promptly.
Thank you, Your Honor.
Thank you both.
Yep.
And